Oh, yeah.
Officer Day, would you open the courtroom for us, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning.
Good morning.
Good morning. Where did Luca go? You are Janiyah Smith.
Yes.
I'm getting another lawyer and he seems to be joining slow.
Okay.
Okay, here he is. Okay, we are on the record. This is case number 22-188237. The file is entitled Michigan Schools and Government Credit Union versus Janiyah Smith. Date and time for pretrial. Our written discovery now in this case is closed. Could I have your respective appearances?
Yes, good morning, Your Honor. Stephen DeLuca, P number P70009 on behalf of Plaintiff Michigan First Credit Union, or Michigan Schools and Government Credit Union.
And your name, ma'am?
Janiyah Smith.
Where are we on this file, people? Our discovery is closed.
Your Honor, last time we were in court, I believe I spoke with Ms. Smith. I believe we had reached an agreement. I told Ms. Smith I was going to send her a stipulated order for conditional dismissal to resolve this case. I emailed that paperwork several times, but I haven't heard back. So I'm waiting to hear from Ms. Smith.
Ms. Smith, what's going on?
I just looked at my email. I'm sorry for the delay. But I will get the paperwork over to you today.
Okay, and how will you send that?
I will send it through email. If not, if that doesn't work, I will send it through fax.
Okay, and do you have my phone number? You can write it down right now if you want.
Yes, I have your phone number.
All right, sounds good.
This is what I'm going to do. So you folks have reached a resolution here. Am I correct in that?
Yes.
Yes.
Okay, then what I'm going to do is I'm going to dismiss the matter without prejudice, noting that my closing documents will be coming forward. Thank you both for coming in. We're off the record.
All right, thank you, Your Honor.
Be safe out here.
You
All right,
too.
thank you.
Bye-bye. Mr. Werber,
Good morning.
good morning. I have Mr. Harris. He's having a little trouble connecting, so hopefully we can get started. Didn't fail, connecting failed. All right, we seem to have everybody. What is your name, sir?
Bradley Harris.
We are on the record. This is case number 22-191-365. Credit Acceptance Corporation versus Bradley Harris. This is the date and time for what appears to be our first pretrial in this matter. Your appearances.
Good morning, Your Honor. Jeff Werber, P67124 on behalf of the plaintiff.
And what is your name, sir? Sir?
Hello, yes,
Mr. Harris, is it your intention to represent yourself in this matter?
yes, Your Honor.
Okay, you have an absolute constitutional right to do that. What you do
Yeah,
have is the right to your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your absolute constitutional right, the same rules that bind Mr. Werber will be binding on you. You understand that?
yes, Your Honor.
Gentlemen, where are we on this file?
Your Honor, I reviewed defendant's answer and it looks like he admits to every allegation the plaintiff alleged. We have not spoke though. So maybe we can resolve this today.
Mr. Harris, is that something you'd be interested in doing today?
Yes, sir. Yes, Your Honor.
Here's what I'm going to do. I'm going to put you guys into a chat room. And you can come back to me when you're finished, okay?
Great.
Now, let
Okay.
me see if I can make the technology work. Let's not get too excited here. Oh.
Hello.
I haven't got you yet. Hang on. All right, let's see, let's try this again. Where'd Mr. Werber go? Breakout rooms, Mr. Harris?
It says David Robinson is inviting you to join room 3.
No, I got you the wrong room. That's my error.
Okay.
You put you in room 3 where you belong. You belong in, no. It's supposed to belong in room 2. Move to room 2. Now it should be joining room 2. Do you see that?
Yes, sir. I'm about to join now.
Okay, you go ahead and join. Yes, sir. Thank you.
All right.
That is Harris. Hello,
Hello,
what is your name?
Brittany Tyner Ward.
All right, hang on for just a second.
Hello, Judge.
Good morning. We are on the record. This is case number 22-189-431. Universal Collections versus Brittany Tyner Ward. Date and time for pretrial, your appearances.
Judge, may it please the court, my name is Attorney Richard Rusin. I'm the attorney of record, and my bar number is 35222.
And tell us your name again, ma'am.
Brittany Tyner Ward.
All right, we were last together on this file on December the 5th of 2022. And the court closed discovery at this time. Have we settled our case?
Now at the moment, Judge, I have no settlement at this time to put on the record. I can tell you that I have filed a pretrial motion for summary disposition. I looked at the proof of service. I think that my proof of service is dated December the 12th. And if nothing else, I would ask at this pretrial for hearing date under the court rules, Michigan court rules, for the motion for summary disposition oral argument date.
Okay, I have your motion for summary disposition. You folks have not been able to settle the case. I'll set the case for hearing on the plaintiff's motion for summary disposition. That will be heard February 6th, 2023 at 10 o'clock.
February 6th.
February 6th, it's a Monday like today at 10 a.m. Plaintiff's motion for summary disposition will be heard on that date. We will send out to you both a notice, and thank you both for coming in.
Thank you, Judge.
Thank you.
Let's be safe out there.
Thank you too.
Hello? Hello?
Hello?
What is your name?
Tamara Ross.
Hang on for a second, please. We are on the record. This is 22-193-775. Beaumont Health versus Tamara Ross. Date and time for pretrial appearances, please.
Thank you, Your Honor. Hal Burke, P69068, attorney for Beaumont Health on this case.
And what is your name, ma'am?
Tamara Ross.
Ma'am, I can't hear you.
Tamara Ross.
All right, where are we on this consent judgment, people?
Your Honor, I would ask Ms. Ross if she received, as I did, I believe, the last time, we emailed it to her December 6th for her to review. She is current on her payment plan. I think there was some confusion as to her receiving it the last time.
Ms. Ross?
I sent it back to both of you guys' emails on the 9th of December. And I tried calling you guys and nobody answered to make sure you guys received it.
The 9th of December, you sent, may I ask what your email address you would have sent it from? And if you read,
Let's hold right
rather
here.
say it in the breakout session, that's
Yeah.
okay too.
Remember, this is on the internet. I'm not sure everybody in the world needs to know the email addresses. So
Sure.
what I'm going to do is I'm going to put you two into a chat room. As soon as you exchange information, come back to me, okay?
Thank you.
Hello?
All right, hang on. Give me a second to get you there.
Sorry.
Thank you.
He may need help getting back in.
Oh, okay. I think everybody's back now. Okay, give me just a second. Pick up your file. Okay, we are back on the record. This is case number 22-191-365, credit acceptance versus Bradley Harris. Appearances.
Jeff Werber, P67124 on behalf of the plaintiff.
And you are Bradley Harris.
Yes, sir.
Where are we, gentlemen?
Your Honor, thank you for the opportunity to discuss this matter in the breakout room. We have resolved this case. The parties have agreed that Mr. Harris is going to pay $3,275 on or before April 9th, 2023 to settle this case in full. We are going to enter into a conditional dismissal, where as long as he makes that payment, the case will remain dismissed. If he fails to pay as agreed, the plaintiff can set aside the dismissal and enter a judgment for the full balance of $16,359.15 plus court costs. I did provide the defendant with all his options on how to make payments to my office.
Mr. Harris, did you hear those terms?
Yes, Your Honor.
Do you understand those terms?
Yes, sir, I do, Your Honor.
And do you agree to those terms?
Yes, I do, Your Honor.
All right, we have a settled case. What I will do is I will dismiss the matter without prejudice, noting that conditional dismissal will be followed.
Yep, and Your Honor, are you going to require me to get Mr. Harris's signature, or can I just file that under the 7-day?
I need a signature.
Okay, then Mr. Harris, I'm going to
Yes.
mail that document to your address on Ellsworth. When you get it, sign it and return it to me, and then I will file it with the court.
Yes, sir.
Okay.
All right,
Great.
gentlemen, thank you.
Thank you.
Thank
Your Honor. I do have a couple more, so
Got a couple more with me?
Yep.
Oh, okay, we'll put you back in the waiting room then,
Okay.
and I'll let Mr. Harris go.
All right, you have a nice day, Your Honor.
Thank you, sir. Let's be safe out there.
You too.
All right, Mr. Burke.
Yes, Your Honor.
Where is Ms. Ross? Let me see if I can find her. She stood in a breakout room apparently. That move her to the main session,
Thank you.
and then we can get started.
Hello.
All right, we are back on the record. This is file 22-193-775. Beaumont Health versus Tamara Ross. Okay, folks, where are we on this file?
Your Honor, Ms. Ross has done everything we've requested from her, including sending back that consent. I do have it now. It's my error. I would ask if you give me until, even if there's an email address, I can send it to you today. If there's not, I can send it to the court either by facsimile or mail today, and it is signed, and this should conclude this matter.
All right, then what we're going to do is I am going to dismiss this matter without prejudice. And then you can just send your consent judgment in, Mr. Burke, as soon as you can.
Your Honor, it is a consent. Do you want to, when you said dismiss it, will the consent still be entered? So
Yeah, what happens is that when the consent appears, we set aside the dismissal and enter the consent.
Okay, great. Is there an email address to get that to the court, or is
Yeah,
it?
you'd have to look on the court's website. There's an email address for us.
Will do. Thank you so much.
Thank you. Ms. Ross, thank you so much.
Okay, thank you.
Y'all be
Have a
safe.
great day.
You too.
Thank you too.
Bye-bye. That it for you, Mr. Burke?
Your Honor, I think I have one other one. That is it for me today with you.
All right, sir. Have a good day.
Have a great day. Thank you.
Mr. Jarbo, good morning.
Morning, Your Honor. How are you?
I'm not bad. How about yourself today?
Doing well.
What file do you have, sir?
Your Honor, it's Kajbu versus Lee. I represent the defendant.
Okay, I've got Mr. Harris. Let's get started.
Your Honor, I don't see Mr. Harris in the Zoom room. Oh, there you go.
We are on the record. This is case number 22-186-770. William Kedgbo versus Jeffrey James Lee. Your appearances, please.
For the plaintiff, Your Honor, Dennis Harris, P35-791.
Mr.
Good
Jarbo.
morning. Good morning, Your Honor. Sam Jarbo, P84564 for the defendant in this matter.
All right. This is Mr. Harris's motion to reinstate the file. The case was dismissed when failed to appear for pretrial.
That's correct, Your Honor, and that was a total and complete error on my part. The date did not find its way to my calendar. I apologize to the court. I missed the date. I'm asking that the plaintiff's claim be reinstated so that I don't have to refile and don't have to reserve the defendant, which would basically be an injustice in light of the fact that it was an error. I just missed the date. I apologize profusely to the court. I've been practicing for almost 40 years. It's never happened before, and I feel terrible about it. I'm asking that the case be reinstated so I don't have to refile. It took us a long time to get the defendant served. In fact, there were 2 previous summonses issued prior to actually getting him served. So I'd ask the court to reinstate the plaintiff's claim and allow it to proceed.
Mr. Jarbo, what is your P number again, sir?
Your Honor, it's P84564.
84564.
That's correct, Your Honor.
I didn't see an answer to the motion to reinstate. What's your position in that regard?
Your Honor, we did send an answer. We sent it a couple weeks back. I apologize if the court hasn't received it, but basically outlining that motion, Your Honor, we were here for a status conference prior to the case being dismissed when Mr. Harris failed to appear. Mr. Harris was at that status conference. You did give us dates, a date on that day to return for another status conference. And the purpose of your adjournment, if you remember, Your Honor, was because Mr. Harris was supposed to send written discovery, which he never did. We never received written discovery. Mr. Harris filed this case way back, took forever to serve my client, wasted the court's time with repeated requests for adjournments, for discovery, for written discovery. what failed to, put a date on his calendar when you gave us a date on the record, and then failed to appear for the hearing, which led to the dismissal. Saying that it was, a mistake is one thing, but the constant theme of the case has been a just empty attempts at moving the file forward, Your Honor. So I'd ask that the case stay dismissed, and that we could, if he chooses to refile later on, we can address issues that are I guess worthwhile to Mr. Harris's client. Although the facts surrounding this matter, Mr. Harris should never be representing his client the way he is. But that's another story.
What prejudice, if any, inures to you if I reinstate the case?
Well, Your Honor, I'd like to explain some of the facts.
No, that's not what I'm asking. I'm not trying the case. I'm asking what prejudice inures to you. And by prejudice, I don't mean that I'm annoyed. I don't mean that my time was used. I mean witnesses that are no longer available. I mean evidence that would have been available that is not available. What prejudice inures to you?
Your Honor, there's a heavy prejudice to my client. The case being filed as it was a huge prejudice to my client. Your Honor, the case.
No, stop. Litigation is not prejudice. Remember what litigation is, Mr. Jarbo. Litigation is a substitute for Mr. Harris's client taking a gun and going to visit your client. That's how we resolve disputes. Litigation is not a prejudice. What prejudice, if any, inures to your client if I reinstate Mr. Harris's case?
Your Honor, I understand that my client is aware of the facts. There isn't a heavy prejudice reinstating the case. However, I would say that there's nothing besides the underlying defense that my client has against the case, Your Honor. I just believe that.
I understand. Thank you. Court's prepared to rule in this matter. 2.612 is in the court rules for a reason. Mistakes happen. Lawyers are human. They make mistakes. There's not been a course of ignoring court orders in this matter by anybody. Things have just not gone smoothly, which is not uncommon. If I've got 10 cases on my docket in the morning, one of them is always going to be a problem case. Yours happens for whatever reason to be it. Court finding there to be no prejudice to the defendant. The plaintiff's motion to reinstate the case will be granted. What I'm going to do, gentlemen, is I'm going to give you a return date with me, and that return date with me will be February 6th at 10 o'clock. Is there anything else we can accomplish today?
Yes, Your Honor, I have one other motion that's up today, and that's a motion to dismiss the counterclaim.
It's not up today because you had no case. How can you have a motion up when the case is dismissed?
Well, but you didn't dismiss the entire case. You only dismissed my part of the case. Their counterclaim never got dismissed. So I did get
We'll give Mr. Jarbo an opportunity to be heard on that one on our next date. We'll hear them both. Mr. Your motion to dismiss the counterclaim. We'll have Mr. Jarbo's response. We'll see you gentlemen both February 6th at 10 o'clock.
Your Honor, I'm sorry. I do have.
Hang on. Mr. Jarbo's got a problem. Go ahead, sir.
Yeah, I've got a conflict on the 6th, Your Honor. Could we possibly do it a different date?
Yeah, do it on the 13th. That work for everybody?
That's
February 13th.
I mean, I don't anticipate it. Yeah, February 13th would be fine.
Okay.
Now, Judge, with respect to the SD motion, you want a new notice of hearing for that?
I will calendar it.
Okay.
I will calendar it today.
Okay, so you don't need a notice of hearing?
No, I don't. I will issue that today.
Okay, great. Thank you, Your Honor.
All right, gentlemen. Thank you.
Thank you. Have a good day.
Let's be safe out there.
Thank you.
We're off the record. Hello? What is your name?
Jordan Irby.
Jordan Irby. Hang on for a minute. I think you're in the wrong place, sir.
I was it said I had at 9:30. I don't know if I didn't get pulled in or I was in the wrong.
What is your case number?
1 second.
Should be in the upper right-hand corner of the notice.
22190602.
Hello? Yeah, you're in the wrong courtroom. What is your
Is it it says Roberts, yeah, this
what
yeah, I
date?
have
What date is?
January the 9th. This like I always come to you.
All right, let me see if this is let's see if this is your case. I don't have you on my docket today, sir.
It says January the 9th.
Mr. Werber, good morning.
Morning.
What brings you here today?
I have two more left, Your Honor. The first
Two
one
more
is,
left? That's interesting. I only have one more case left.
yeah, well, it's possible that one is you received the settlement documents on the other one. The first one is credit acceptance for Pittman. Do you have that one?
That one I have.
Yep. Though I had credit acceptance for Terrell Sparks, but we did submit a settlement document. I wasn't sure if you received it or not. Obviously you did, and
Terrell Sparks is set at 11 o'clock, sir.
yes, that's the one. We did submit a conditional dismissal on that one.
Okay. I have another case here I'm having a problem with. So let me put you back in the waiting room. And I'll see if I can figure out this other problem.
Okay.
Sir, give me your case number again, please.
2219060
22
1906002.
602.
Yes.
22190-602.
Yes.
Okay. Let me call and see if I can't figure out what's going on. Because I do not have you on my calendar today, sir. Hang on for a moment, please. Hang on, here's my help right here. Hello? Sir, you're in courtroom 534.
Okay, fine. Okay.
I'm in 539. You want 534, sir.
Okay.
All right. Have a good day.
You too.
All right, Mr. Weber, let's finish my morning call. This is case number 22-192911, Credit Acceptance Corporation versus Anthony Pittman. We were last together on this file on November 28th, At that time, the matter was set for pretrial today, January 9th at 10 o'clock. It's now after 10:30. Your appearance.
Good morning, Your Honor. Jeff Werber, P67124 on behalf of the plaintiff.
Mr. Werber, the defendant has failed to appear. No good call that failure having been shown. The default of the defendant is hereby entered. We'll send out an order for you today, sir.
Great. Thank you, Your Honor.
Appreciate you coming in.
And then on that 11 o'clock, like I said, we did submit a conditional dismissal. I checked the ROA and it hasn't been entered yet. We mailed it to the court on December 27th. So it should.
Yeah, right. During the Christmas holiday, you thought
Yeah.
something would get delivered. All right, let's do this, Mr. Werber, since you're here, rather than having you come back at 11. Let's call the 11 o'clock case, and I can just rely on your representations as an officer of the court.
Great.
This is file number 22-191704, Credit Acceptance Corporation versus Nicole Terrell Sparks, Nakia Terrell Sparks. This matter is scheduled for a motion today at 11 o'clock. It's now 10:39. Could I have your appearance?
Jeff Werber, P67124 on behalf of the plaintiff.
Mr. Werber, you want to tell me something about this case?
That is correct, Your Honor. The parties have entered into a conditional dismissal. Both defendants signed it. I signed it, and we mailed it to the court for filing on December 27, 2022. According to the Register of Actions, it has not been entered yet, but I'm sure you will get it across your desk soon.
Accepting your representation as an officer of the court, the matter will be dismissed without prejudice. We'll look forward to your conditional dismissal.
Great. Thank you, Your Honor. Have a great day.
Sir, you too. We're off the record. Mr. Burke?
Your Honor, I apologize. In fact, I just logged in to my phone as well. I'm just gonna cancel off of that one.
Okay.
So you let me in here.
I got two of you. What's up?
I do have one other case. It is Beaumont Health versus Monique Patterson.
Yeah, that's not up till 11 o'clock. You want me to
11.
release you or put you back in the waiting room?
I'll just log back in then, and I did just
Okay.
receive an email from her attorney. So
Okay, great. Talk to you then at 11.
I will be there. Thank you.
Thank you, sir. We're off the record. Morning, counsel.
Good morning, Your Honor.
What file are you, what file are you here on?
Yeah, I'm sorry. I don't know why, for some reason, this never saves, even though I try to change it to the correct number. I'm here on the Resilient Life Care versus the City of Detroit, file number 22-190371. I'm gonna change it here so it reflects my name, so it reflects that.
You've got the plaintiff?
Correct, Your Honor. We represent the plaintiff.
I have Mr. Patterson.
Yeah.
We are on the record. This is 22-190-371. Resilient Life Care versus City of Detroit. Date and time for what appears to be our first pretrial on this PIP case. Your appearances.
Good morning, Your Honor. Amanda Winiger appearing on behalf of the plaintiff, Resilient Life Care, LLC.
Bar number.
P79498.
Counsel.
Good morning, Your Honor. Ben Patterson on behalf of defendant City of Detroit, P85118.
Okay. First question, obviously, is whether the 2.302A disclosures have been made.
Yes, Your Honor, we did file our initial disclosures on November 29th of 22. So,
And Mr. Patterson, you made yours?
Yes.
All right. What are we arguing about here then? This is a PIP case, for crying out loud. Come on.
well, yes, Your Honor. So obviously the issue is over residential services from Resilient, and we thought that the only issue here was over the reasonableness of the charges, but after reviewing defendant's initial disclosures, they are also taking issue with the relatedness of the services.
Okay.
So
what is your claim, Ms. Winiger? What's the
well,
dollar?
it's our claim that the services that Resilient provided are related to the patient's accident-related injuries.
Okay. I'm sorry, I wasn't clear. What is the amount of your claim?
Oh, the amount of our claim, I think there's a total of a little over $19,000 that's been billed, and they've only paid like $5,000. but there's also a network agreement in place between our parties, so, let me see, I think we just filed. I'm gonna try to get you the total here, Your Honor. So it's looking like we're saying that there's a total of a little over 9,000, so $9,273.60.
So you're nowhere near my jurisdictional max is what I'm concerned about. You're nowhere near my $25,000 limit.
Right.
That's what I'm concerned about. Mr. Patterson, what's going on here?
Your Honor, this is related to a claimant named Roderick Arnold. He was involved in an incident in 1979. In 2020, he separately fell and injured his knee and has had some attendant care services and prescriptions and things related to the knee injury. And this is one of those. We filed a motion for summary disposition in a different case, which Judge Hennett Johnson granted. It was a prescriptions case where the prescriptions were related to the knee injury, as these attendant care services are here related. So that's our position on this, is that this is unrelated to the motor vehicle accident and therefore is not covered under no fault.
When did the motor vehicle accident occur?
1979.
Ms. Winnegar?
Well, Your Honor, this is not a prescriptions case. This is a residential care case.
I got that.
The services are for supervision and cueing because the claimant has a traumatic brain injury.
This is help me if my math is wrong, but this sounds to me like a 40-year-old injury.
Well, Your Honor, it's a traumatic brain injury and it's a lifelong injury.
Sometimes they are, sometimes they aren't. How
Well,
old
in
is
this
your
case, it's our
client?
position that these services are prescribed with regard to his traumatic brain injury.
How old is your client?
Well, Your Honor, we represent Resilient Life Care. We don't represent the patient.
I'm sorry. How old is the patient?
Not sure off the top of my head, Your Honor. I have to look to see when his date of birth is. He was born in March 13th of 61.
61, so 39 and 23, 50, okay. All right, so you guys have done your disclosures and there's really nothing I can do at this point in time.
Well, Your Honor, we would, and I apologize for interrupting you. Go ahead.
No, please.
I was just going to say that we would ask for, a period of discovery so that we can, find out more about their claim about the services not being related. And we'd also like to take the deposition of their claim representative.
Mr. Patterson?
I would be happy to have discovery and exchange provide. The claim rep deposition is something we generally oppose. And I would oppose here as well. That's something that's done usually on the eve of trial. If you're not able to get something resolved on the motions.
Let's do this. I am not making a decision in regard to the claim rep, but I am opening written discovery in the file. And we'll see how our written discovery comes along. And then we'll try it again, February 6th at 11 o'clock. Does that work for everybody?
Yes, Your Honor.
Ms.
Yes,
Winnegar,
Your Honor.
I am not ruling out nor ruling in the deputy claim rep. At this point, my position is my experience has been that written discovery very often is able to narrow the issues at minimum and most times actually resolve them. But it's another thing. If we get to the point where we're done with our written discovery and you still think you need a deposition, file your motion or you see if you can guys work it out between you. If you can't work it out, I get paid to make decisions.
I understand that, Your Honor.
Now, is there ongoing claim for you?
I think, make sure. I believe this is a closed period of time, Your Honor.
Okay.
So
Get,
it's not
get
ongoing.
click, okay, then I don't have to worry again about whether I have subject matter jurisdiction. I will see you guys again February 6th at 11 o'clock. Your written discovery is now open. Is there anything else we can accomplish today?
Not that I'm aware of, Your Honor.
Mr. Patterson?
No, Your Honor.
All right, thank you both for coming in. We're off the record. Let's be
Thank
safe
you, Your Honor.
out there.
Have a good day.
Thank you, Your Honor.
Thank you. Appreciate you coming in. Mr. Burke?
Yes, thank you, Your Honor.
As soon as Mr. Randazzo checks in, we can get started.
I'm here, Judge.
Okay, good morning, gentlemen. This is file number 21-167134. Beaumont Health versus Monique Patterson. Date and time for pretrial. Gentlemen, your appearances.
Thank you, Your Honor. Hal Burke, P69068, attorney for Beaumont Health on this case.
Daniel Randazzo appearing on behalf of Monique Patterson, 39935.
All right, gentlemen. This case is old. We had a pretrial back in January of 2022. What's going on here?
Judge,
Not only is it old, Your Honor, but Mr. Randazzo emailed me today with a request, and in all due respect, it's a fair one, but a unique one because, as you know, it's an old case and it's gone from pro se to attorney to pro se to back to attorney. I'd like to try to figure out a way to resolve it.
Judge, I did some discovery. Hal has provided that discovery. I provided that to Ms. Patterson, and she has not responded to me. And so I think there was a breakdown in communication with her, and it's very difficult for me to, move forward with this case if she's not going to communicate and basically listen to my advice. So I would like to do an oral motion to withdraw.
I will not grant an oral motion. What I will do is I will do two things. I will close your discovery as of today. I will calendar for February 6th at 11 o'clock, both the pretrial and your motion to withdraw, Mr. Randazzo. Make sure your motion to withdraw indicates in it that you have advised your client of the date and time for that hearing with a proof of service. And we'll see what happens at that time. I mean, this case is getting old.
I agree. I know.
I agree. Could you repeat that date and time, Your Honor?
That's going to be February 6th at 11 o'clock.
And that's still by Zoom? Is that okay?
Mr. Burke, I don't believe I'm going to be in person again. The Supremes, unless they change their directive, have told us that we are supposed to do as much as we can virtually. And
I vote for that.
I really don't see the need to have lawyers in my office, in my courtroom for motions and pretrials.
I wish you could explain that to some of the other courts, Judge.
I agree.
I got to tell you, I was resistant to you at the beginning, but I just think it's just so much more efficient.
It is. It's totally efficient.
So much more efficient. And at some point in time, we stopped using quill pens and we moved on to fountain pens and ballpoints. So
And
although
typewriters
slowly, the profession can change. Not very quickly.
Typewriters to computers.
Now,
I agree. I agree with everything
I
you
think you
both are
still have
saying.
to have, I think you have to have trials in person.
Yeah, I've tried one case.
I don't know how you evaluate credibility on a TV screen. I really don't.
Very difficult.
But
Not
for trials and motions and legal matters, I just don't see the need in lawyers coming down here. Come down, pay $20 to park, hurry up and wait, spend 12, 15 minutes with the court, and then drive back to your office. And it just doesn't seem to make sense to me.
I agree, 100%.
All right, I'll file my motion and we'll see you on the
February
6th.
February 6th, 11 o'clock.
Very good.
Thank you, Your Honor.
Thank you, gentlemen. Let's be safe out here.
You too.
We're off the record. Mr. Stratton?
Good morning, Your Honor.
Good morning. Let's see if we can't get Mr. Cohen here and get started on this oldest case on my docket.
Uh-oh.
Mr. Cohen, where are you?
I'm trying to,
You have got audio? Now I've got video.
now
All
I've
right,
got it.
gentlemen. This is file number 22-178276. Dearborn Total Automotive versus Olivia Martin, Richard Caldwell. Date and time for pretrial on the oldest case in my docket. Gentlemen, your appearances.
Good morning, Your Honor. Trevor Stratton, P65124 on behalf of the plaintiff.
Leslie Cohn for the defendant,
Bar number.
34889.
Where are we, gentlemen?
Your Honor, last time we were here, the case was successfully reinstated against defendant number 2, Mr. Caldwell.
Caldwell, I believe.
Correct. Shortly after that, I did resend the default and all proofs of service. I just checked the register of actions. It doesn't look like it's hit the system. I know with the holidays, it's probably backed up. So
Probably.
that's kind of where we're at.
Okay, where are we with Mr. Cohn's client?
Well, we're not really anywhere.
What I hear from you saying is in regard to Mr. Caldwell, it's just a mechanical thing now. It's for the paperwork to catch up to the files.
Right.
What's going on with this other file, gentlemen? With the other portion of the case, I should say, excuse me.
Well, not much has happened. We have been kind of treading water, working on Mr. Caldwell. Obviously, given that should be resolved shortly, as well as the fact that I'm sure you want to push this case along, I'll have to get in contact with Mr. Cohn and see what we want to do.
I'll give you guys another date, February 6th at 11 o'clock. In the meantime, by that time, Mr. Stratton and I anticipate that the default will at least caught up with the file. We'll at least get that entered and get started on that aspect of killing the case.
Agreed.
It's time to kill this file, gentlemen.
Understood, Your Honor.
Either that or put it on Social Security, one or the other. February 6th, 11 o'clock, gentlemen. Thank you.
Thank you, Judge.
Y'all be safe out here.
All right, you too.
We're off the record.
Goodbye, Your Honor.
Bye-bye. Good morning, Counsel.
Good morning, Your Honor. I got a call from Nick Balderman this morning, and he is going to be representing the defendant, Miss Slappy. I don't know if he's in your waiting room or not.
He is not. So
Okay.
I'll put you back in the waiting room and we'll wait on Mr. Baldwin.
Yeah, and if he doesn't come, I told him we settled the case this morning. So I told him that I would also report to you that we settled the case. I've already sent him the consent judgment and we're going to submit it. So if he doesn't show up in the next few minutes, that's what's going to happen. So
Fair enough. Put you back in the waiting room. I'll get back to you at 11:31, no later than that.
all righty. Thank you, Your Honor.
Thank you, sir. All right. Morning.
Good morning, sir.
Balderman connection, we can get started. All right, we are on the record with 22-188-042. Gateway Financial Solutions versus Robin Slappy. Date and time for pretrial, your appearances.
Good morning, Your Honor. May it please the court, Scott Schisler, P 48832 on behalf of the plaintiff.
Good morning, Your Honor. Nick Balberman, P 35262 on behalf of the defendant.
Mr. Balderman, you're 35262?
Yes.
Okay. All right, gentlemen, where are we?
Your Honor, I got a phone call from Mr. Balderman. He just got retained by Ms. Slappy, but we were able to reach a resolution. I have emailed him a proposed consent judgment, and we should be able to get that paperwork to you very quickly.
Mr. Balderman?
That's 100% accurate, Your Honor.
So you guys got it done.
It's
This is
done.
what I will do. I will dismiss the matter without prejudice. Looking forward to your consent judgment.
Thank you.
Sounds
Your Honor.
good.
Anything else,
Thank you.
gentlemen?
No.
Let's be safe out there. Thanks for coming
All right.
in.
You
Thank
too.
you.
We'll see you, Nick.
Okay, thanks.
Take care.